Lordship. Lordship, I wanted to mention 5 minutes, Lordship, for hearing. MSC case, Lordship.
Ready for hearing?
Yes, Lordship. Paperwork has been filed, already ready, Lordship.
Yes, give it.
Lordship may be permitted to mention there are 3 matters, all are arising out of the motor accident claim cases for the enhancement of compensation. Everything is ready, my lord. It is ready.
All are
ready.
separate. All are separate.
3 separate matters.
3 separate.
Yes.
Have you informed the other side?
Lordship.
Have
My
you
lord,
informed?
the other side has already been informed.
Okay.
Item number 1.
Actually, dictationটা বন্ধ করো। Yes, next.
Item number 2.
Nobody is there. Pass over.
My lord, I am appealing for the petitioner.
Yes.
My lord, but it's a preemption case and the preemptee, lordship. Now, my lord, I have come against the order of the passed in the mispreemption appeal, which has been arising from the mispreemption execution case.
Execution.
Execution case, lordship. Preemption case, I lost. Preemption appeal, I lost. Thereafter, the preemptor filed the execution case. In the execution case, my lord, the report of the Nazir has been taken care of, but the Nazir says, my lord, that land could not be identified. In spite of that, the execution order has been passed, against which I filed the appeal. In the appeal, lordship, the order has been passed dismissing my appeal on the ground of limitation. Now, lordship, I have served copy to the preemptor, but my lord, the postal tract says that the addressee is absent. Therefore, my lord, there is a direction to serve. My lord, I took information that this person is not there. Even, my lord, I could not identify who is the person, who is the learned advocate, conducting advocate before the trial court.
So in appeal, your section 5 application was
Rejected. Last paragraph of the impugned order, Lordship, can
how,
you come?
how much delay was there in preferring the appeal?
Yes, Lordship. That is that, delay application is in page 42. 86 days delay. Page 42.
42.
Yes, your Lordship. Mispreemption appeal, page 42
42 of your
of my petition,
original
Lordship.
application.
Of my, yes, of my CO application.
42.
42 and 43.
What document you have submitted before the appellate court
My
for
lord,
your
it was
showing the
on the ground of, my lord, the medical issues.
Hmm.
But what I have found from the order, my lord, the observation is at the time of hearing, the learned lawyer for the appellant did not file any document before the court regarding pendency of any oh, my lord, there is another issue, my lord. A partition suit is also been filed, which is pending because the land is, my lord, within the unpartitioned land. So, my lord, the partition suit is pending.
Between whom?
Between the co-sharers of the plot of land within which this suit plot is situated.
But your case is that you unable to prove that you are the adjacent plot holder.
Yes.
And there was any relations between you and the seller.
My lord, yes, that is my lord.
So you failed to establish your case
But my
before
lord,
the trial court.
execution case, I have filed the, my lord, the Nazir's report. That is page 23A of my petition. Nazir report says, my lord, that the suit plot is not, my lord, identified.
No. You have filed the appeal before the district judge.
Yes, regarding my lord, challenging the execution
dismissal
order.
of your suit.
Execution
Yes. Case.
Yes.
Execution case or miss appeal.
Miss appeal, my lord, challenging the execution order. My lord, the execution order is in page 35, which is under challenge before the appellate authority, which has
But
been.
you did not fulfill the condition
My lord,
of
it is, my lord, it is-
allowing your section 5
My lord,
application.
it is, my lord,
If you
purely
do
on
not file the
my lord, it is purely on technical ground, my lord.
technical ground, but
My lord,
you have
for the
to
ends of
satisfy
justice,
the
my
court.
lord, for the ends of justice, my lord, can it be sent to the learned appellate
No,
court for
no.
rehearing of the same? Because, my lord, the Nazir report is very much clear that the suit plot could not be identified.
No, we are not talking about the merits of the case. We are only considering the section 5 application was rejected
My lord,
by
my
the
humble submission
by
before
the
your
appellate
lordships,
court.
my lord, if there is merit in the case, my lord, that should, my lord, the technicality cannot be the bar for adjudication of the same lordship. Kindly consider.
Have you served the copy of
My lord,
other side?
I have served the copy. That is what I am, my lord, submitting before your lordship.
And what was the order, earlier order? There was some, what document you want to rely upon? In order to enable the petitioner to ascertain in that regard and to furnish such further subsequent report, if any, let the matter stand adjourned. What subsequent report you want to file?
My lord, the section 20, page 23A is the report of the Nazir. My lord, the Honorable Court in the earlier occasion asked me as to whether subsequently any other report is there or not. My lord.
So there was no any.
My lord.
There is no any.
That instruction I have not yet received, lordship. My lord, the report of the Nazir, that is page 23A, lordship, kindly comes for a moment.
Page
23A. Before that, page 23, lordship, comes for a moment.
1 minute. As there is no boundaries is mentioned in the writ.
Only the plot being number 1208 Mouja Horibanga and the quantity of land, i.e. 42 decimal, is mentioned.
demarcated the schedulant but could not identify or demarcated the said 47 days.
Said,
So
plus
due
said
to lack
42
of-
decimal, my lord, how can it be? It's an unpartitioned plot amongst which 42 decimal cannot be identified. Even, my lord, the plaint, there is no boundary.
So according to you, why you have not served the copy?
My lord, I have served the copy, my lord. Now, my lord, the opposite party, my lord, he is found absent.
Absent
not-
is the good service.
Lordship, in that
Report
case, Lordship,
has been sent.
Yes, absent. Lordship, kindly, absent.
Once again, you serve the copy to the learned advocate before the trial court.
Lordship, I am trying. Lordship,
No.
kindly keep.
Item 4,
My lord. Passover, my lord.
Passover.
Passover, my lord. Short Passover, my lord.
Okay, sir, Passover.
I,
Well, I am for the petition. I pick it up, sir. Okay, admit which should have been there. The matter has already been admitted and the affidavit of service is already duly served.
Dispatch service none appears.
And appears. Although in this matter, my.
What is the case?
application- My application under Order 7/11, read with section 151 of the CPC has been rejected by the learned trial court. Challenging the rejection of my application under Order 7/11, I filed this application. Mara takes up the impugned order, the last of my.
The rejection of application filed under section 7 rule 11
Yes,
of the CPC
yes. For
is
rejection of
not a
claim.
deemed degree.
Matlab?
Is not a deemed degree.
Well, rejection of my application is, if the plaint had been rejected, then it would have been a decree, and appeal would have lied before the appellate court. But since my application under Order 7 Rule 11 has been rejected, so 227 will lie.
So what are the ground for rejection?
Malad, can you take up the order impugned? And then last of my application. Malad, order number 12 dated 9th of April 2026. Certified copy.
CPC আছে তো? There were two applications, one
Yes,
order
two
6
applications were
rule
heard.
17
I have no objections against the.
regarding amendment.
Yes, Order 6 Rule 17 was filed by my other side. If that application, I had no objection against that, but my contention was that even if the application under Order 6 Rule 17 was allowed, that would not improve the suit. The suit miserably failed on account of the fact that it is being barred by the provisions of Article 60 of the Limitation Act especially. Article 60 of the Limitation Act expressly states that while claiming cancellation of a deed which was executed during the minority of any of the parties, the limitation period is 3 years from the date of attaining majority.
But you know that limitation is the mixed question of
But there is
law
a
and
specific,
fact.
there is a specific bar. Malad. There's a specific bar under the Limitation Act that an application for seeking
The
cancellation
limitation application cannot be allowed.
for cancellation of a deed, which was
That can be decided at the final
cannot be, my
hearing.
lord. The suit is itself barred. The suit is itself barred by law. That is why I have invoked the provision under Order 7, Rule 11, Clause D. My lord, takes up the
The suit.
relevant
One
article.
minute, 1 minute, let me go through the order.
Yes, my lord. Yes.
Your ground was court has not have the pecuniary jurisdiction, number one. Number two,
Yes.
the
Barred by
suit
law.
is barred by limitation, as Article 60 of the limitation
Yes.
stipulated the deed can
Clauses
be
B and
challenged within 3 years.
Clauses B and
Attaining
D
of
of Order
majority
7.
of the transferee concern.
It is now settled law, my
The
lord.
learned plaintiff further argued that no permission was obtained by the guardian to sell off the property of the minor, and the executed of it was himself. Therefore, the sale was an issue. Also, he relied on judgment showing so.
And the judgment relied on by the learned trial court is also not proper.
It is not required, and degree pass sitting inside the same. Further relied the following judgment to maintain petitions are pending the prayer for amendment to be considered first. This is a settled position of law that the brother is not a guardian but a defective guardian. Upon death of the father, the grandfather became the legal guardian of Muslim. Position is usual. Father was clarified with words.
The learned trial court proceeded on an entirely different aspect while considering my application under Order 7, Rule 11, Clauses B and D.
Rightly held that my view is similar. The limitation cannot be decided at the initial stage.
But this is a state.
Under Order 7, Rule 11.
Order 7, 11,
Can you
provision
show
is
me
itself-
can you show me the ground?
Well, it takes up the Limitation Act. Well, it takes up Article 60. of the
Limitation Act, each and every case has some limitation.
So, in order
For
to
filing
a
limitation,
suit
for
filed
filing
beyond
any
the
suit,
period of limitation,
that is,
a suit which is filed beyond the period of
but that
limitation,
will
and
not
also-
come under
also not-
under the Order 7, Rule 11.
Well, that also not by 1 year or 2 years. A deed of 1982 has been challenged, my lord.
Maybe.
At the most, that deed could have been challenged within 3 years from the date of execution of
All
the deed.
this.
That is within 85.
You know.
1985
you-
it was the last date within which the deed could have been challenged, but that was not challenged. If this is permitted, then there would be multiplicity of suits over the issue. Then a person who is executing a deed today, or their guardian executing a deed today, sometime later after 25 years or 40 years, that person would come up and file a suit against the persons who have now acquired right title interest in the property, challenging that no, that deed was executed during our minority. We do not abide by that.
Do you have any authority that even if limitation is there,
Yes.
the plant can be rejected?
Yes, I have a
And
categorical.
you know very well that the limitation is the mixed question of fact and law that should be decided
This is
upon trial.
But this is a fact wherein there will be multiplicity of proceedings if the suit is
No,
permitted
no,
to proceed to trial.
That will be decided by the
kindly takes
trial.
up this aspect.
Hmm.
If a party who today sells one property, if that party is allowed to go back on his own executed instrument and come up 25 years later.
I understood that after majority, attaining majority, they have filed the suit
No,
for
they have
cancellation.
filed it belatedly. My lord, the deed is of
for
1982.
cancellation.
My lord, the deed is of 1982. My lord takes into account the deed is of 1982. At that period of time,
Please show me any authority
my lord,
if
I'll
you
then, my lord
have.
keeps it any day in the next week. I'll come back with judgments.
This. My lord, the password item number 4, kindly takes up item number 4.
Wait, item number, this is 5, no? The 4, call the 4.
Passover matter item number 4. I am petitioner. The challenge is petitioner being a plaintiff and a petition order 22 rule 1 to withdraw the suit and liberty to fight afresh. That has been my petition. Kindly come to my petition.
Impugned order dated 29/1/2026.
Lordship, my petition kindly come to is my petition, Lordship. That has been petition annexure P4 30, is number 30. What is 30? Lordship, there is a typographical mistake actually. That is in the order 23 rule 3, but not with a 1. This is in rule 1, sub rule 1. Within bracket 3. That has been mistaken by part of the plaintiff petition. And Lordship, the petition has been filed to withdraw the suit.
No,
And
page number 38. You are showing page number 38.
30.
An application under order 23 rule 3. You have wrongly
Wrongly typed.
mentioned,
Lordship, this wrongly typed.
in place of 23, you have mentioned 3.
Yes, one by sub rule 1, sub rule within bracket 3. It only written here the old rule number 1.
That is the mistake.
Mistake. And Lordship, the Garnet trial court accepted the disregard with that typographical mistake and stated in paragraph number 4, considered that the order 22 rule 3 is not appropriate. Rather, I have to file order 23 rule 1 within bracket 3. This is my part.
What is the prayer? Prayer portion?
Withdraw the suit with the file afresh, Lordship. Kindly my prayer portion is number 40, Lordship. And last part, it is prayed that Corona would recess me please to allow instant withdrawal petition and allowing the plaintiff to withdraw the present suit, giving liberty to file plaintiff afresh suit in the same cause of action and pass. That is my.
It was not admitted, no, earlier? The
No, Lordship,
application
no,
has
no,
not been
no,
admitted.
Lordship. Kindly admit this and admit that point of view and the, I may be directed to issue notice upon them. In the meantime, the suit may be taken. Lordship, because of there is a multiplicity proceedings have to come out. In the meantime, some of the legal heirs filed a partition suit, some of them sold the property. That's why I going to withdraw that.
Why you have filed the suit for
For declaration.
for declaration and
Declaration and injunction.
injunction?
That is my thing.
So what was the mistake in your suit?
Is there, Lordship, kindly come to my page number 31, P3. In another case, some person.
Partition suit. You have filed the partition suit. Another person.
Where I was designated as defendant number 37 to 39. 37 to 39, and whom I have filed the suit, they have been also implicated as a party. They are in party number, Lordship. They are also dependent, Jalpaiguri in.
No, another ground was taken by the trial court that only one plaintiff asks for withdrawal.
Yes.
With
And,
liberty.
out of
How only one person can ask for withdrawal?
They are three brothers, Lordship.
Whoever may be,
they are,
all plaintiffs
Lordship.
need to be file application.
Lordship, in the meantime, Lordship, they are if the procedural matter that can be asked me.
Procedural matter.
Lordship, because of the three persons, I am the look after this suit.
No.
And Lordship, that has been
That is
question.
not permissible.
Lordship-
How
Lordship-
it is
Lordship-
permissible? You
Lordship,
file a
the-
fresh
because-
application. You file a fresh application.
Lordship, in this regards, Lordship, because of the This is
Two
where,
grounds has been taken by the trial court.
Trial court.
First ground is you have not mentioned the caption properly.
that has been our. it's my
Another
mistake on my-
another ground is there are several plaintiffs, only one plaintiff filed this application
three.
for.
3 plaintiffs I have to.
So you want to withdraw, how court will allow?
Lordship, because of they are the 3 brothers, that's why.
Maybe.
Lordship, because of they.
Tomorrow if you withdraw, the other brothers will be prejudiced.
Lordship, in this
So I
case,
think this order is not,
in this case, Lordship, they
Not is liable
court
to
may
be set
ask me
aside.
to join ask me to the other plaintiffs should be joined here.
how I can,
Lordship, that's
you file a
Lordship,
fresh application, there is no bar.
Lordship, in this.
Is there any bar? You file
No,
a
no,
fresh
no, Lordship, that is been
application.
over. Lordship,
Item 6.
Mr. Bhai, back to appear with the respondent one.
6 this arises out of a preemption proceeding 2 dismissals since there is no second appeal, hence this revision. It will take some time if kindly takes it up tomorrow
Tomorrow.
tomorrow.
Yesterday you are not there.
I was not there, your lordship was annoyed that we are
No,
not
not
pressing the
annoyed. I do not understand why advocate do not appear.
No, I was
There are several friends. There are several juniors advocates.
I was before courtroom number 6
This practice I have seen, it is unfortunate to say from here that one matter dismissed thrice for default.
not this.
No, I have seen. And one after another restoration application filed.
Milord, if I
Even
may-
today, I have dismissed many CAN applications
Restoration.
which was filed for restoration. This is the situation I have seen.
Milord, if you are
At
kindly-
the level of High Court, if such situation arises, the litigant will suffer ultimately. Who will suffer? Advocate will not suffer. Ultimately, case will be hampered and the litigant will suffer.
Milord, if Milord
That is
kindly-
the situation here. So, this is my request to all advocates who are present here. At least one advocate must be there to take adjournment. Adjournment we will allow if there is a sufficient ground.
আগে কেউ ছিল না?
You want tomorrow?
Tomorrow, Milord, Milord can take it up as the first matter
No,
tomorrow. at
no,
2 p.m.
it
Milord,
will remain in the same position.
Same
I will
position.
take up.
And the
Okay,
lordship
on the
pleases.
prayer of learned.
Which place? Item number 8.
7.
7 not the speaker.
You see the cause list? There is mention, somebody has mentioned yesterday. देखो नॉन
Lord, item number 9.
9.
I am appearing for the petitioner, Lord. Lord, I am praying leave to appear virtually. Lord, this is a
the
civil
appellant,
petition.
the opposite party was served despite service non-appears.
Non-appears, yes. Lord,
Okay, you
ready,
proceed.
we are ready with the matter, Lord.
Yes?
We are ready, my Lord. If your Lordship desires to hear it out, my
Yes,
Lord, we
yes,
are
you
ready.
proceed your case.
Lordship. So, my Lord, this is an application, my Lord, which arises out of a order passed by the learned trial court, my Lord, on an application under order 18, rule 17 of the CPC. Now, my Lord, I will take your Lordship to the facts first. Why, my lord, this application is preferred? Lord, the suit was filed in the year 2015.
Suit
More
was
precise-
filed by whom? Suit was
By me,
filed by
by me.
you.
By me, my lord, yes, I am the plaintiff.
Suit was filed for?
Suit was filed
for?
for my lord, declaration of title, my lord.
Declaration and?
Declaration and injunction.
Declaration and injunction, okay.
Yes. Now, my lord, may kindly come to,
Permanent injunction and
yes, kindly
Yes.
come to page 23. 23A is, my lord, the type copy of the order, first order of the London Trial Court. My lord will find
Yes.
the date. That is 21st of September 2015.
Yes.
Yes. Now, my lord, I take your lordship to the next page. Order dated
By
20
that order, defendant was restrained from disturbing the peaceful possession of the plaintiff
Right, right.
over the suit property.
Yes.
Yes.
Ad interim injunction was granted in my favor.
Granted in your favor, okay.
Yes. Now, my lord,
Then
next
after,
page. Next page, my lord, kindly come. My lord, bear with me for 2 minutes, my lord. I'll.
yes, you can proceed, no problem.
Yes. Page 24, my lord. Order dated 29 September 2016. Next page.
Yes,
My lord sees the
Yes.
order file lawyer Hajira and a petition praying for so and so hard considered allowed. Defendant filed 2 petitions praying for time to file WS and WO. Statutory period for filing WS and WO has been over. Hence, prayer for time is rejected. Let the suit be proceed ex parte against the defendant. So, my lord, this order was passed almost 1 year after the institution of the suit. Now, my lord, the
yes, 1 year.
yes, next page, my lord. Order dated 25th of January 2017. My lord, by this order, my ad interim injunction was made absolute. My lord, despite the fact that the defendant filed petitions for praying for time. My lord, kindly see the order. Today is fixed for hearing ex parte injunction. Plaintiff files Hajira. Defendant files 2 petitions praying for time on the grounds stated therein. Let it be kept with the record. Learned advocate for the plaintiff moves the petition under Order 39, Rule 1 and 2, read with Section 151 of the CPC. On perusal of the record and connected documents, I find that if the order of ad interim injunction with order number 2 dated so and so is made absolute, then neither party would be put to any jeopardy and it would also serve the purpose of justice. In view of the
Yes,
forward-
your interim order was extended till disposal of the suit.
Right. So, my lord, this order was passed in the year 2017. So, almost 1.5 years after the institution of the suit. Now, my lord, next order, very important, 24/4/2017. In the same page, my lord will find the defendant files WS and WO by affidavit with application under order rule 9, rule 8, rule 7, order 9, rule 7 with verification cases adjourned. Next date, 28 June 2017. The application by the defendants were taken up for hearing and consideration. My lord, the court allows the application for the defendant and vacates the order by which the suit was made expired with a cost of rupees 500. My lord, astonishingly, on the very next date, next lordship will find 8/9/2017. After 3 months, order. Plaintiff files lawyer Hajira, defendant takes no step today, no cost paid by the defendant, hence let the case be proceed ex parte against the defendant and is adjourned. So, that order, they could not take avail of the
No
order.
cost has been paid and again hearing was fixed ex parte.
Yes, yes. Now, next date, just beneath that, 20 January 2018. Again, defendant files an application under Order 9, Rule 7, praying for vacating the execution. This application, next page, consideration order, lordship will find in 29. There is a repetition below, 28, kindly ignore 29. Direction, upon the defendants by that order effective to pay the cost, but in spite of specific direction, defendant did not pay the cost. So this application was considered and rejected on contest. Miller 2018, next order 2018, 29/5/20. Again, same application was filed under Order 9, Rule 7 of the CPC.
After rejection of the same,
Yes. This
another
application-
application filed.
Yes, application filed. It was taken up for hearing on the next date, Milord, 14/9/2018, page 30. It is very important. But I'll read it out, Milord, the operative portion.
The second application is also allowed, subject to payment of cost.
Yes, yes, but with observations. With observations. Milord, kindly see the observations before the penultimate para, Milord. It starts perused and considered. After that, it appears that it is a fact that on 2 occasions similar prayer was made by the defendant, and on 28/6/2017, the order to proceed ex parte against the defendant was vacated to payment of cost of ₹500, and the next date was fixed on 8 September 2017. But on that day, the cost was not paid and the defendants also did not take any steps. Today, the learned advocate is submitting that his mother passed away on 5th January 2018 and does not seem to have any relevance to the default, the payment on 8/9/2017. However, the petition is considered as the final and last chance. This court is inclined to allow the petition in the interest of justice. Milord, with 500 rupees cost, the application was allowed, the ex parte was vacated. Now,
So earlier cost was not paid.
not paid.
This is the second cost was imposed.
Yes. Now, Milord, this is 28. Thereafter, we come to Milord 2022. Milord may recollect this suit was filed in 2015. Now, Milord, 2022 order. Page 31, Milord. Today is fixed for PH, both side files Hajira. Plaintiff files amended plaint, let it be kept with the record. Now, Milord, very important, none appears on behalf of defendant on repeated calls. PW1 so and so is present in court and filed affidavit in chief. Milord, he was examined in full on ex parte. So, Milord, 2022, Milord, after 7 years, the PW1 was finally examined in full in ex parte because the defendant chose not to represent. On the very same day, Milord, will find in the latter part of the order, in the same order, Milord, 15/9/2022, in the bottom part, later 15/9/2022, time 12:45 p.m. Defendant files a petition praying for adjournment on the ground that the defendant number 1 is an aged person and unable to attend before the learned court along with the relevant documents. Therefore, proceeding of the cross-examination of the plaintiff is not possible today. No objection is raised. Time period is considered and rejected. Now, Milord, kindly appreciate one thing. Lordship knows, with your Lordship's vast experience in the trial courts, Milord, even if the defendant is not physically present, the counsel, the advocate for the defendant can very well cross-examine the plaintiff witness. There is no problem in that. So this ground was not taken, was not accepted by the learned trial court, and very rightly it was rejected. Because after 7 years of the suit, the first witness was going to be examined and there was no proper ground, Milord, to defer the examination of the witness for such frivolous reasons. Now, Milord, what happens? Now, I come to the impugned order directly. Milord will find that
Even PW2 was also not cross-examination.
Right. They have prayed for deferment of the PW2 because they have filed an application under order.
3 occasions they have not cross-examined.
Right, Milord. So, Milord, on 7th of September 2024, they files an application under Order 18, Rule 70 for recalling of the PW1. Milord, that application was allowed by the learned trial court. My lord, challenging that order, my lord, we are before your lordship in the year 2026. My lord, it's been 11 years, my lord, the suit is pending at the stage of examination of the witness, PW1 and PW2, only because of, my lord, the lackadaisical and the dilatory tactics adopted by the defendants. Now, my lord, kindly come to
Whether 800 was, 800 cost was paid to you subsequently, 800 cost.
my lord, that I have to take instructions, my lord. I do not know whether it was subsequently paid or not. Now, my lord, kindly come to page 37. That is the impugned order, my lord, which is under challenge before your lordship.
Yes,
My lord, I'll read it out. my lord.
37.
37. my lord. This is order dated 8th of January 2026. Today is fixed for passing order. Hajira is filed on behalf of both the parties. The case
No,
may
no,
be-
whether cross-examination of PW2 was completed.
No, my lord. I believe no, because it was deferred. I believe it has not
Please
yet.
take instruction whether PW2 was cross-examined or not,
Lordship,
or even partly cross-examined or not.
lordship. My lord. My lord, should I come back with this instruction tomorrow or should I continue?
Yeah, tomorrow, yeah. Tomorrow. And another thing, you have to take instruction whether 800 and 500 was paid cost or not.
My lord.
Earlier cost imposed by the trial court was paid or not.
Lordship.
To take instruction and thereafter you come tomorrow, I will see.
My lord.
Because several occasion courts was imposed. Time and again, the trial court was given sufficient opportunity to the other side
Lordship.
to proceed with the case, but their intention was to drag
My lord.
the case intentionally. It appears from the record that their intention was not good, and they tried to drag the matter from 2015 to 2019.
Lordship. And they have been,
So
to a
one
large extent, my lord, they have been successful.
successful. Let us see whether they will success in this court or not.
I'm grateful, my lord. I'll come back tomorrow with instructions.
Tomorrow you take two instruction. Thereafter you come.
My lord. Good.
Item number 10.
Where is affidavit of service? You are
My lord,
opposite
I'm for the
party.
opposite party, my lord. My lord, I'm praying for kindly fix this matter next week, my lord.
Why?
My lord, I've just yesterday received copy, my lord. Day before yesterday, my lord.
Supplementary, why you have filed the supplementary affidavit?
Division application was filed without certificate copy.
Oh.
Leave of the honorable court. The certificate copy. Certificate.
My lord, telling 7th, my lord, next week, please.
Why, where is
6th or 7th, my lord.
7th?
7th, my lord.
7th. Come with preparation.
Milord, I am for the opposite party. Milord, this revisional application was admitted, Milord, earlier by your honorable coordinate bench. But subject to correction, Milord,
Nobody is there.
material facts have been suppressed.
Nobody is there.
So let, takes, Milord, if Milord takes it up, Milord, any day, Milord, subject to lordship's convenience, Milord.
Which order challenge?
Milord, kindly sees, Milord, an order, Milord, directing police help for implementation of an order of injunction, that is 27th June 2024. That was, Milord, challenged. Now, Milord, this...
Interim order passed in presence of both sides?
No. I was the plaintiff in the suit. We obtained an order of injunction, and that was upon service of notice. The notice was served. They did
Despite
not...
service, none appears on
They
behalf of the defendant.
refused acceptance. That was treated as good service, and thereafter an contested order of injunction was passed in absence, treating the non-acceptance as good service. Subsequently, Milord, this order of police help was obtained. This petition
For violation of the interim order.
for non-implementation
What
of the
was
order.
the interim order?
Wait. Milord, kindly takes the previous page.
Yes, you are for the petitioner. Yesterday also you sought for adjournment.
And they appeared in the suit subsequently after passing of this order by preferring an application for setting aside of ex parte. Now, how this order can be challenged, Milord, that remains a question.
Until and unless the same is vacated, the police help can be continued. Where is the
Correct.
problem?
Absolutely
You have
correct.
to obey the order.
And no appeal against that order of injunction has been taken out.
Next day. Huh?
Grateful, Milord.
Preemptorily लेकर देंगे. Preemptorily.
সাতটা কি বার হচ্ছে? সোমবার বোধ।
Item 12.
It's a direction for service upon the respondent project. And that's a project. Satisfied me.
When such order was passed for face service?
First order was passed on 4th December 2024. You are appealing.
Yes. Lordship, I filed a CAN application, may serve upon my learned senior, the copy.
Can application?
CAN application for withdrawal of the partial amount deposited by the petitioner.
Withdrawal of the partial
amount.
You know what is CAN 3? CAN 3 is
That is the
party-
CAN 3. There is the opposite party respondent's prayer.
This is your application.
This is my application, Lordship.
Okay, this is a death case.
Death case, Lordship.
Death case.
Death case.
How much award allowed by the trial court? Tribunal?
32.96 lakh.
And what are the grounds for appeal?
Two vehicles were involved in lordships, but the landed court has passed an order against only one vehicle lordship. That is the collision between.
Head-on collision. He has made a party to the another vehicle. If another vehicle was not made party, you are liable for entire. Why you have not added them? In trial court, whether that vehicle owner, vehicle insurance of that vehicle was implemented as a party?
Other insurance company was the party also.
Party. They did not contest. So what was the observation of the tribunal regarding involvement of that vehicle? Which paragraph? Which page of the judgment narrated about the involvement of two vehicles?
Case number 44.
44. No, in original certified copy, 44 in your appeal. Can application, can 44. Yes, 44, come to the 44. Paragraph 4. Huh?
For the 14.4, specifically submission that since the accident was network pollution and the same was occurred in the middle of the road, so both the vehicle, that is the minibus and the truck, equally contributed to the cause of the accident. Therefore, both the vehicles are liable. He referred in several decisions mentioned above. Raised the plea for contributory negligence and 50/50 liabilities. Considering the above discussion, I am not interested to take the results from the submission of the contributory negligence, not a single came from the side of court, and the court suggests that both the vehicles were liable for the aforesaid accident. It appears that the hypothetical argument, considering the fact that the police submitted charge sheet after investigation, the aforesaid criminal case and on being satisfied about the crime of case, it is made the driver of the aforesaid truck liable.
So is there any document you have produced before the tribunal to show that the other vehicle was also involved and due to both drivers, the accident was taken place?
But if you wants to get the final, then fix it Monday also, because
No, I am asking for allowing his application for withdrawal of the amount. If you are liable wholly, then I will allow his application. Or if you are partly satisfied, you satisfy that, yes, you are partly satisfy this court that you are only entitled to pay 50%, then I will allow accordingly his prayer.
when we keep it on Monday also, because the petition.
How much money you need to withdraw? 50%?
Lordship, that is not as your
Prefer?
lordship, as your lordship maybe pleases considering the situations of the petitioner of the respondent lordship.
Monday also, because my challenge is that the.
No, he may withdraw his awarded amount.
What the.
Your point is only you are liable for 50% of the awarded amount. You have deposited entire amount. I will allow at least 50% amount he may be withdraw. Why he will wait till final disposal of the appeal? When you are admitting that you are only liable for 50%, so it is your specific case. So he may be allowed to withdraw partly amount. Otherwise, the person will suffer. How many applicants are there?
Two applicants are there.
Two applicants.
Two
Who are they?
The wife and the son.
One
of the
and
deceased.
son is minor or major?
Major.
Major. Both are major.
Both are major.
At the time of
At the
filing?
time of filing.
At the time of filing.
Yes. And the wife is very aged person.
So at least 10 lakhs should be allowed to be withdrawn. Take instruction.
See his petition lordship. There is.
Okay, tomorrow. Having heard the both side, leave this matter. Tomorrow. What is can and can do? How many days delay? 72 days. Who is other side? Have you solved the copy? No effective service. Not ready. Already served to other sides. All sides. Tomorrow. You prepared a file because I have to pass order. Next week. On 8th. Okay, not this week, next week. On 7th or 8th. Make referee. Fourteen, 15, 16, 18. 14, 15, 16 and 21. All are arises out of the same incident. So, separate case. The one by one, please come one by one. 14. Condonation of delay. How many days? 97 days. But the actual delay is 67 days as per the official report. Yes, you have solved the copy? Where is the affidavit of service? So how case will proceed without affidavit of service? Yesterday you are not present there. Okay, not this week. In all cases, effective service was made. In all cases. দেখুন এসিটা কমাতে বলো না, এসি একটু কমাতে বলো। Who is appearing for the appellant? Pasupati Nath Swarup Das. No, appellant is here, Kiran Bala Mandal and another. So Pasupati Nath, who is Pasupati Nath? Swarup Das. Appellant. Nobody is there. Section 5 is there. I think they are not interested to proceed with the case. Yes. Appeal was admitted. There is no direction for preparation of paper book. Paper book is required. Other side is not there. You have solved the copy despite service non appears. Award has been paid. Mhm. Please come this side. You are the. Yesterday, similar prayer was made from your side. দেখুন Can আচ্ছা হ্যাঁ লিখে দিন তো লার্নেড কাউন্সিল। এটা রাখো এই এটা রাখো। এটা কি মাইক কাজ করছে না? আর ইউ লিসেনিং ডিকটেশন? আর ইউ লিসেনিং? অলওয়েজ ইজ আস্কিং। IFCO Tokyo General Insurance Company, who is the advocate here? Yes? The order passed on 10/6/2026 to file supplementary affidavit disclosing the reason for delay. That opportunity was given by the coordinate bench despite yesterday no one present. Should I dismiss? ওয়ান ওই যে অর্ডার করলাম না ওই যে ডিপোজিট No direction for paper book. What are the grounds for your appeal? So what was the direction? You have deposited the statutory amount as well as 4 weeks expired. What was the direction for payment? 4 weeks. Where is the judgment where it was observed that the vehicle was insured and the insurance policy was valid? Where is that observation?
We have to give the DW,
The insurance policy was not exhibited.
Cover note was exhibited, police officer.
Cover note is sufficient,
Police officer has not seen the document.
whatever may be the situation, but the copy of the insurance policy or cover note was produced before the trial, before the tribunal.
No, this is by our form. We have already urged the evidence.
So that was forced.
Yes, all document.
You have taken that plea.
Yes, we have taken all.
Where is your submission in the judgment? Submission was recorded by the tribunal. Where is that? Please show me.
In the judgment.
Which page? Which paragraph? So you are attending the court without preparation, without any brief. Very surprised. Whatever may be, you should prepare yourself. Whatever question put by the court, you have to answer then and there. Service has not been complete. What service is required to complete? You have to prepare the paper book.
It has not sent to the claimant. Okay, it has not been served.
Next week or not this week. Yes. You have served the copy, no? Do you want to file any objection? 7,167 days delay. And other defect was cured.
I have got already been cured by the trial court order itself. Submission made, deletion made, everything is there in the trial court order. No.
लिखो तो that was brought Okay, next circuit bench, he will file their an opposition, if any, with regard to the limitation application in the meantime. আচ্ছা এটা এক কাজ করো 2 weeks
Your Lordship, I am for the respondent. In 29, I am for the respondent number 1 and 2.
I am for the appellant. Spirit Millet is a second appeal.
it was admitted.
It was admitted, it's for final hearing. Well, it's a very short matter, Millard. I won't take more than 15
Your
minutes.
Lordship, before taking up the present application for stay, it is my submission that the appeal is not maintainable. Not maintainable. Second appeal is not maintainable on law point.
Okay, I will take care of your submission.
I like to refer your Lordship. I like to refer section 43, order 43, rule 1U. Order 43, rule 1U.
Wait. Yes.
Millard, the
Impugned order is
initially Millard, the lower court passed an order of eviction that was appealed against. Now, in the appellate court had remanded back the matter for adducing further evidence on behalf of the defendant. Now we are up against Millard that order of remanding back. That order of remanding back. Now, Millard,
Yes, Your Lordship, that's why the appeal is not maintainable. Second appeal is not maintainable. Actually, this is appealable order.
Please wait.
Oblige, Your
Please wait, Mr.
Millard, the point of maintainability that is taken, Millard, probably the point of maintainability is that it should be treated as a second miscellaneous appeal. Now, Millard, my submission on that is, Millard, since it is an order of remanding back, thereby, Millard, it has remanded back before the learned trial court. Even, Millard, the second appeal is maintainable. Because other than that, Millard,
I think the remand was due to lack of some evidence adduced by the parties
Millard, not lack of. But I will show, Millard, by passing an order of remanding back, an order of this honorable court has, Millard, been completely ignored. Millard, kindly text, Millard. I will just show, Millard, 2-3 orders, Millard, that will clarify the situation. Millard, kindly text, Millard. Sir, either you submit or I submit.
Please wait, sir. Please wait, one by one.
Oblige.
কথা বলেই যাচ্ছে। Millard, kindly text, Millard, page 496.
496.
Page 496
অন্য
of the stay application.
Record 496.
496.
Yes.
Yes. Millard, plaintiff files lawyer Hazira, defendant files petition under section 151 CPC. Praying inter alia to recall the order dated 3rd May 2014 and to give an opportunity to the defendant to adduce evidence. On perusal of the
You
record,
are defendant or plaintiff?
I was the plaintiff.
You are the plaintiff.
On perusal of the record, Millard, the order of eviction, Millard, is in my favor. On perusal of record, it appears that on several dates, viz. So and so, the defendant has prayed for time. Furthermore, by order number 69 dated 3rd May 2014, this court already refused the prayer for prayer for time
Prayer
made by
made by
defendant.
the defendant.
Yes, now the order number 69 dated 3rd May 2014 was passed by this court after sufficient judicial contemplation, and there is no scope to modify and or set aside the said order by the self-same court. The prayer as made under section 151 CPC is refused on contest. Now, Millard, from all these dates, Millard would find only on 2 occasions the the plaintiff has sought time, and in all those dates, the defendant Millard has sought the adjournment. Now, this order dated 21st May 2014 was carried, Millard, in a civil revisional application before this honorable court. Millard kindly takes that order once. Which
By the
Millard,
defendant.
by the defendant. That is at page 515.
515.
Copy. Yes.
Yes, 515.
CO 2142 of 2014, order dated in the matter of order dated 21st May 2014, passed by the learned Civil Judge Senior Division. Now, Millard kindly comes to the ordering portion, that is at page 517. The petitioners will serve the opposite parties and inform them the matter will appear 3 weeks hence. The petitioners are put on notice that unless a deposit of rupees 2 lakh is made with the trial court, subject to the further condition that such amount will stand forfeited in favor of the plaintiffs, if the suit is decided in favor of the plaintiffs, the order impugned may not be interfered with. So they were put on notice.
So that 2 lakhs was not deposited.
Not deposited. Thereafter, Millard, the
That
second.
was the condition
the
that
next-
if you deposit 2
If
lakhs,
you-
then
if-
you will get chance to.
Maybe the court will
consider.
interfere the order, considering the number of adjournments they have taken to adduce evidence. And this evidence, Millard, was of DW3. DW1 and 2 has already adduced evidence, and I have, Millard,
And they have also cross-examined.
cross-examined everything, all the relevant documents that they could have brought on record on the date of when the case was on trial was brought on record. I have annexed the entire Millard, the exhibited documents for that purpose, to demonstrate that nothing remains to be brought on record. That is why, Millard, the brief is thick. Now, Millard, text page 518.
After this order, what have done?
Millard, next page. Kindly then turns over to the next page. Since the petitioners do not wish to proceed with the petition, CO 2142 of 2014 is dismissed and not pressed. So the matter, Millard, reaches a finality. Dismissed and not pressed, Millard, has a certain implication in law. I need not, Millard, address your lordship on that. The lordship is well aware.
So that order is give finality.
Attend finality so far as reopening of evidence is concerned. Therefore,
He will not get chance to
they
contest the case.
cannot avail any further chance to Millard adduce any further
Adduce
evidence.
further evidence.
Now, therefore, that's where the appellate court has went wrong. Now, what the appellate court has observed, Millard kindly takes the appellate order.
Annexed in the
Annexed in the stay application, it is in the memo of appeal also.
stay application. Which
Yes,
page?
stay application, page 544, the ordering portion.
544. Yes.
That the title appeal be and the same is allowed on contest subject to payment of cost of rupees 50,000. The judgment and decree dated so and so passed by the learned Civil Judge Senior Division is hereby set aside. And this second line, Millard, also addresses the point of maintainability. Since it was set aside on a particular ground, Millard, the order has to be carried in a second appeal. There is no other remedy for me. Let the case record be sent on remand with direction upon learned court below to allow defendant numbers 1 and 2 and the plaintiff to adduce evidence as per my observation in the body of the judgment, and after completion of evidence, we will pass a fresh judgment. Further directions, Millard, regarding payment of cost. So on this ground, which the Honorable Court in a revisional application exercising jurisdiction under 227 has closed for all practical purposes, and since no SLP was preferred from that order, this Millard ought not have been passed. And this could not have been a ground for setting aside the order of the trial court.
Even 50,000 is not disputed.
No, never.
Till
This probably Millard was deposited by them. Millard, I'll just take instructions. 50,000 deposit was there. And therefore, Millard, this second appeal. And Millard will kindly take just the note of the points on which the second appeal was admitted. Millard, the court was very clear while admitting it. That is,
What
Millard,
was the observations made by the appellate court? Which paragraph?
Millard, even Millard, those
What observations? made?
observations, Millard would, yes, Millard. Kindly, Millard, takes Millard. From page 543, Millard, middle portion.
543. Yes.
Middle portion, Millard would find, of course, the matter has been dragged. If Millard is with me, for not adducing evidence by evidence on time, due to that, plaintiff has to suffer, and for that he should be compensated by the defendant, but it does not mean that the defendant will not be given opportunity to adduce his evidence from his side. As such, to matter relating to trespass totally depends upon the nature of the suit property. If it has been decided that it was purchased out of joint family fund, then defendant will have to right to reside in the said property. Obviously, no counterclaim has been filed, but at the time of deciding whether these defendants number 1 and 2 are trespassers or not, the status of the property must be decided. And if it is decided that it is joint family property, then it will affect the prayer of the plaintiff. Hence, I think proper opportunity should be given to the defendant to adduce evidence from his side. I also find the submission from the learned lawyer of the defendant 1 and 2 that he could not comply of the order of the Honorable Court due to financial hardship, and hence it should not be hurdle at the time of deciding the case in appeal. So this was, Millard, the justification as to why it should be remanded back. But so far as whether it is a joint property or not, defendant DW 1 and 2 has adduced sufficient evidence, which is on record, and it cannot be said that they have been deprived of the opportunity entirely. Now, after adducing certain amount of evidence, if you want to develop your case further,
they have got opportunity to adduce the
yes,
evidence
DW,
from their side.
Yes, DW1 on doc exhibited several documents, cross-examined, discharged. DW2 affidavit in chief exhibited documents, cross-examined, discharged. They wanted to adduce further evidence by way of DW3 in order to bring in further evidence if they can collect anything. Now, certain amount substantial,
That was not allowed.
that was not allowed. Millard has seen the order under 151, which the lower court has taken note of on how many dates they have taken adjournments, and the evidence was closed, carried in a civil revisional application before this honorable court, dismissed as not pressed.
What was the question framed by the division bench in this?
Yes,
appeal?
Millard. Millard kindly takes the order dated 6th July 2023. The substantial question, 3 questions were framed. May I read out, Millard? 6th July 2023.
Yes.
Whether or not the impugned judgment and order of the learned court below, in fact, is an instance of judicial overreach, wherein the letter and spirit of the order dated August 19, 2014, passed in CO 2142 of 2014, has been ignored and diluted. Second, whether or not the learned court below ought to have appreciated that considering the surrounding facts and circumstances, the issues ought to have been finally decided and the dispute should have been given a finality without opening the gates for further trial, which in fact shall result in further unreasonable and unjustified delay. Whether or not the learned court below, while deciding the first appeal, ought to have entertained and adjudicated the application under Order 41, Rule 27, in order to assess whether the defendant respondents in fact are in a position to adduce any further evidence which might have been of any substance.
Who are they?
They are the trespassers sitting on my property since 2000.
What is their claim?
Nothing. They claim that it
And
is a...
suit is for partition.
No, it's suit for eviction.
Oh, eviction.
Millard, if Millard desires to have a look at the plaint, Millard, I'll just show the plaint once.
Eviction of trespasser or eviction of tenant or whatever?
Trespasser, Millard.
Trespasser.
Page 21.
The trial court has given a degree in your.
The degree in my favor.
Yes, anything more?
In brief, my lord, that is my submission. And my lord, the only very scope of appeal is very limited. Whether the remanding back was justified or not, in view of the fact that issue for adducing further evidence was finally
Was
closed by this
already
honorable
closed by the.
By this
trial
honorable
court as well as.
affirmed by the
affirmed
honorable
by
court.
Not affirmed by the High Court, but High Court has given one more opportunity upon.
That was
deposit
not
of the
availed.
2 lakhs rupees that
Yes,
was not
not
deposited.
availed by them.
Subsequently,
Dismissed
they
as not
withdrew.
pressed. Dismissed
Withdrew
as
the
not
case,
pressed. Not withdrew, my lord, dismissed as not
dismissed
pressed.
as not pressed.
Yes.
That
So,
means
so that means it attains finality. Had it been withdrawal,
So that order is finality. Thereafter, that order cannot be reopened at the stage of appellate.
at the stage of appeal again by the appellate court.
Yes.
And particularly when, my lord, order 41, rule 27 was an avenue.
50,000 has been deposited or not?
Deposited 50,000. No, it was not accepted by the registry. Since the second appeal was
is
pending, probably
and
that's
stay
right.
was granted.
Stay was granted.
Stay was granted.
Stay was
That's why the
Yes.
amount was not received.
Yes.
May I start your lordship?
1 minute.
May I submit? May I submit your lordship?
Yes, yes.
Your lordship kindly peruse their memo of appeal. They have read out the impugned order, judgment and order, and they have also annexed. They have also annexed one information whether the final decree of the case has been drawn up by the learned court or not. This judgment and order was passed by the learned additional district judge, first to Siliguri. No decree was drawn. Finally, take a note that no appellate decree was drawn by the learned appellate court. No decree was drawn. Only judgment and order was passed. So this provision, this appeal, second appeal, is hit by section 100 of CPC. Section 100 of CPC says what, your lordship? Kindly peruse section 100 of CPC. May I be permitted to read the relevant portion?
Yes.
Section 100, second appeal. Save as otherwise expressly provided in the body of this code or by any other law for the timing in force, an appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court. So, learned additional district judge, First Court Siliguri is the subordinate to the Honorable High Court, and there is no decree. Second appeal will lie only when the decree is passed by the learned appellate court. In the instant case, admittedly no decree was drawn. They have annexed the information obtained from the learned appellate court whether decree has been drawn or not by the learned appellate court, and answer is no. In stay application, they have also annexed the same document that is no, with answer no. So section 100 says that second appeal will lie only when the decree is drawn. So in the instant matter, no decree was drawn, so second appeal will not lie. Secondly, your lordship, kindly peruse section 104 of CPC. Section 104 of CPC. Order from which appeal lies. Order from which appeal lies, an appeal shall lie from the following orders. And last clause, that is I. Any order made under rules from which an appeal is expressly allowed by rules. So this is appeal from orders. The appellant ought to have filed first appeal before the Honorable High Court against the impugned judgment and order, because section 104 of CPC permit him that it is an appealable order. Now, any order made under rule from which an appeal is expressly allowed by rules. Now, your lordship, kindly peruse order 43 rule 1U. Order 43 rule 1U. Appeal from orders. Rule 1U. Order 43, Rule 1U.
Yes.
Rule 1 says an appeal shall lie from the following orders under the provisions of section 104, namely U, an order under Rule 23 or Rule 23A of Order 41 remanding a case where an appeal would lie from the decree of the appellate court. So this is an appealable order but not an appealable decree. This is distinction. Now please peruse, your lordship peruse order 41, Rule 23 and 23A. What says? Order 41, Rule 23 and 23A. Remand of case by appellate court. Rule 23, Order 41, Rule 23. Remand of case by appellate court where the court from whose decree an appeal is preferred has disposed of the suit upon a preliminary point and the decree is reversed in appeal. The appellate court may, if it thinks fit, by order remand the case and may further direct what issues shall be tried in the case so remanded, and shall send a copy of this judgment and order to the court from whose decree the appeal is preferred. So this 23 is not applicable because our suit was not decided by the learned appellate court on preliminary point. Our suit was decided on full-fledged when decree was passed by the learned trial court and the appeal was heard full-fledged. Now, Rule 23.
What preliminary issue was raised before the trial court?
Your lordship, 23 is not applicable in our case. Rule 23 is not applicable in our case. In our case, Rule 23A is applicable. Rule 23A. Where the court from whose Rule 23A.
Yes.
Where the court from whose decree an appeal is preferred has disposed of the case otherwise than on a preliminary point. So our suit has been appealed and the learned appellate court below has decided the issue as a whole, all the issues, otherwise than on a preliminary point, and the decree is reversed in appeal. In our case, decree is reversed and retrial is considered necessary. The learned appellate court considered the matter for retrial, sent the matter remanded back to the learned trial court for re-evidence. The appellate court shall have the same power as it has under Rule 23. So, in our case, the suit was decided in favor of the plaintiff against the defendant, against which the defendant number 1 and 2 referred their first appeal before the learned appellate court, that is learned additional district judge, first court Siliguri. And while deciding the said appeal, the learned additional district judge, first court Siliguri, reversed the decree passed by the learned trial court and remanded back the matter for further evidence. So this is an order, judgment and order, but not a decree, because no decree was drawn in our case. And accordingly, as per provisions of Order 43, Rule 1U, appeal will lie. So first appeal will lie before the Honorable High Court as per observation made by the Honorable Supreme Court.
So according to you, the judgment and order passed by the first appellate court is an order, not a decree.
Yes. It is an order, not a decree.
As decree was not drawn up.
Yes,
That is your contention.
Yes, and there is one supporting judgment is there of the Honorable Apex Court, AIA 2012, Supreme Court 3788. My colleague is there and she will hand over the copy of this judgment to your lordship for perusal. In para number 15 and 17. In para number 15 and 17, the Honorable Apex Court has decided in so far as the present case is. In caption also your lordship will find appeal against order of remand, tenability, order of remand passed by court while reversing decree passed on merits. So in our case also the decree was passed on merits and it was reversed. Order as such is one under Order 41 Rule 23A. Such order of remand is amenable to appeal under Order 43 Rule 1U. Rule 1U. It is an appealable order, so appeal will lie, but not second appeal, first appeal before the Honorable Court. Now, para 15. In so far as the present case is concerned, the trial court had disposed of the suit on merits and not on a preliminary issue. The first appellate court set aside the judgment and decree of the trial court and directed the trial court to decide the suit afresh after giving parties an opportunity to lead evidence, oral as well as documentary. The nature of the order passed by the appellate court leaves no manner of doubt that such order has been passed by the appellate court in exercise of its power under Order 41 Rule 23A of Para 16. Order 43 of the court provides for appeal from orders. Clause 0 of Rule 1 under Order 23 was amended and upon insertion of Rule 23A in Order 41, which effects from February 1, 1977. It means that under appeals a lie from the following orders under the provisions of Section 104 U. An order under Rule 23 of Order 41 remanding a case where an appeal would lie from the decree of the appellate court. It now para 17. It is clear from the above provision that an order of remand passed under Order 41 Rule 23A is amenable to appeal under Order 43 Rule 1U of the court. So, according to these observations of the Honorable Supreme Court, I like to refer another judgment of the Honorable Kerala High Court, which is reported in AIR Online 2021 Kerala 892. Similar, in the instant matter, the Honorable High Court has observed second appeal not maintainable. First appeal will be maintainable. First appeal against the appellate order before the Honorable High Court. Not the second appeal. And if your Lordship will peruse the name of appeal, it is admittedly a second appeal. Second appeal is not maintainable in all such papers. Including state petition, appeal is second appeal.
Which paragraph you are referring? Which paragraph you are referring in this judgment?
In Kerala, in Honorable Kerala High Court, Your Lordship, 6, 7, 8, 10. 6, 7, 8, 10. Para 6. Para 6, para 7, para 8, and para 10.
Anything more?
Your Lordship, second appeal is not maintainable. So I humbly pray that let the matter second appeal as preferred by the appellant be dismissed.
Okay.
Yes. So, Millard, can I, Millard, consider these judgments and come back tomorrow?
Please indicate whether degree was drawn up by the appellate court or not.
Yes, Millard, I will.
That should not be, because how
Millard,
degree
according to me, Millard,
because order,
if there is a
it is treated
judgment,
as an order, then
no, Millard, the only thing is drawing up of a decree is a ministerial act pursuant to an adjudication. Now, once there is a detailed judgment,
not only ministerial work, but degree from which appeal can be left.
yes,
As per the
but if Millard,
section 100.
yes,
If
Millard,
there is no degree,
if the
then
department does not,
automatically
if
that
the
judgment
department,
and order will be treated as an order.
Millard, if the department does not draw up a decree, what will be the consequence? Well, let me see, Millard,
How degree can be drawn up when the case is remanded back for fresh decision? No decisions was done by the
no, Millard,
appellate court.
even then a decree can be drawn up.
How?
Because, Millard, even when a suit is dismissed, A degree is drawn up because decree is a formal expression of adjudication.
But appellate court has not not drawn up the degree, and it cannot be,
Let me consider, Millard. I will come back with my response.
because the remand order is not a final judgment.
But it has
Final
set-
conclusion
it has
of the.
set aside
because
the judgment of the trial court.
Appellate court whenever decide the suit, that is a continuation of suit and least before the appellate court.
Yes.
That must be decided in finality. That was not decided in finality, and it was remanded back for fresh evidence. So there is question of drawn up degree does not arise.
But a
And when
judgment
there
and
is
degree
no
has been
degree,
set aside also.
and when there is no degree, second appeal will not lie. That is the submissions made by the
Yes. Millard, let me
other
consider,
side. So
Millard.
please,
I will come back.
please come with some authority also if you.
Yes, Millard.
Item 30. The lordship may be kept as top of the list. Top of the list.
Second, no, it will be remain in the list and it will be taken up on second. No
Obliged.
problem.
Obliged.
This case, my lord, the award has already been granted by the honorable court. Subsequently, at the time of the disbursement, the land register found that the petition number 2 has added the major root. So on this basis, we have filed one CAN application. Thereafter, during the CAN application, we have not annexed any documents to prove if that the
That's the birth certificate has not been enclosed or other conclusive proof of her. Only one person. Only one.
already the major one.
Who has already withdrawn the amount?
Amount has not been withdrawn.
Why?
The
Oh, minor.
So I am submitting the supplementary having the birth certificate so that he has added the majority and it's a completely
Supplementary. Can. Oath already disposed of us. Offer order of.
Number one has that. Do not have three applications. One is
Can one.
one is substitute abatement, sitting as an abatement, one is repetition and one is substitute.
Where is other side?
Notice, one of the notice is not a production from next Wednesday in the meter.
No, next circuit, next circuit. Adjourn date तो होगा ना, date ता तो fix नहीं. It should be before.
There's a party in this particular worship and reached and confused second. And
What finality, what is the dispute between the parties? What settlement is going on?
Order 14.
What was the suit file and what is the suit?
Suit was regarding tenancy. Eviction matter was there.
Eviction of the tenant.
Violation
You are
of-
the plaintiff or you are the?
We are the
tenant?
defendants, Lordship. We are the
You are
tenants.
the tenant.
Tenants, Lordship. Lordship, subsequently now, the respondents have also agreed and come into a conclusion that a fresh tenancy will be executed amongst us, and hence the
Where
kindly.
is the other side?
Lordship,
Who is appearing?
Mr. Shubham Sarkar usually appears.
Where is he?
Lordship, probably I have not seen him since morning. Lordship, kindly keeps it on Tuesday because Mr. Ray is, I'm led by
Okay,
Mr.
not this week, because last occasion both were present and
Lordship.
on the submission of the both parties, the matter was adjourned
Lordship, Lordship,
to arrive settlement,
Lordship. Much obliged.
not this week.
My lord, on the last occasion that there is a direction to serve the notice because the.
Why you have not appeared yesterday?
Yes, my lord.
Why you have not appeared yesterday?
Yesterday I missed the list.
Huh?
I missed the
You missed the list.
Thursday that was that I missed.
What type of advocate you are? You missed the list. 4 pages. If you go to the High Court Calcutta, you will find a voluminous
There is
false list.
So it was the last on the last occasion it was directed to to serve the notice because the order 9 rule 4 is not applicable because order 9 rule 9 is applicable, and as such there is direction, but the service is not complete. It may be kept on 8, which will in the meantime the service will be complete.
Did you send? Did you send
I have sent, but it is not complete. In 8th, it may be kept.
Okay, not this week.
In 8th, in Monday.
I will not fix, not this week.
That issue
34th, my lord. On the last occasion, there is a direction to file the death certificate of the deceased because one of the petitioner has died. And today I have filing the supplementary affidavit with the death certificate.
Who has expired?
Petitioner number 2.
Petitioner number 2, Vishwanath. Yusuf Chaudhary.
Vishwanath Chaudhary.
Can
1, can 3.
within time.
Within time.
Which paragraph you have mentioned the legal heirs?
The applicant also.
Is the applicant?
He died, and after his death, how many legal heirs are there? Which paragraph you have mentioned? Whom you want to substitute?
Yes, para number 3.
Para number, seriously, the above mentioned facts and the present applicant being the legal heirs of the deceased Chaudhary required to substitute in place of petitioners are?
Applicant here.
Where is the petitioners? Why you have not mentioned the name of the petitioners?
Petitioners are in the cost title.
Where is
Dinawala
that?
Chaudhary.
Huh?
In the Dinawala Chaudhary cost title.
Oh. Dinawala Chaudhary, Utpal Chaudhary,
Tapos Chaudhary, all the legal heirs of deceased petitioner number.
and 5 and 6 is the daughter of Vishwanath. You should have mentioned these names in the paragraph itself. Okay. Likhun. list this matter.
It's the extension application.
Expired.
Within time, extension is filed within time.
The interim order is expired.
Expired.
Who is other side? Other side is not there.
We are sub, but they are not applicable.
Okay, next week. Affidavit of service.
Service is there.
How many respondents?
There. Respondent number 1 to 6.
Affidavit of service filed on
It's ready for hearing, but time starting out.
both parties are there.
My
Next
lord.
matter, Lordship. Excuse me, Lordship. Next matter, yes.
Oh, 35?
Not this one.
The 35 not today.
My lord, just a
30.
moment. My lord, the affidavit of service is here. My lord, let me submit the affidavit of service. My lord, previously this matter was dismissed by Justice Devanshu Boshak on 6th January 2026 and later
No,
on
this
13th
is
May.
civil appeal. This is the main appeal.
Yes, my lord. It's a FMT, MACC matter, my lord. Motor accident.
Who is
claim
other
case.
side?
My lord. Actually, my lord, I'm
Paper
not.
book prepared.
No, my lord, we need the direction to prepare the paper book and also to call for the trial court record, my lord.
This matter is pending since 2022 and you are asking today for paper book preparation.
My lord, actually, this is a newly appointed matter to us. Previously, another advocate was
So
appointed.
it
for
was
this
not
matter.
admitted as yet.
My lord, actually, on 13th May 2026, this matter was restored after it was dismissed. And my lord, in the last order, there was a direction that this order should be served upon the respondent insurance company. And here is the affidavit of service, my lord.
Okay, I'll take up tomorrow.
Okay.
Keep it.